It's a great and distinct pleasure for me to join you this evening in this historic community and participate in paying tribute to some very important places, persons, and concepts in American history. This community was, of course, the site of the historic battle in 1863 that turned the tide in the effort to preserve the Union. It was here that President Lincoln delivered his famous address, paying tribute to government of the people, by the people, and for the people. It has been my privilege, as you've heard, to serve on the board of directors of the Gettysburg Foundation, responsible in partnership with the National Park Service for the magnificent new visitor center and museum not far from here. And if you haven't seen it, you're the poorer for it, and I would urge you to do so. To speak under the auspices of the Eisenhower Institute has a special significance for me as well. President Dwight D. Eisenhower was the very first presidential candidate for whom I could vote, and I did so. And he won twice. The principles that President Eisenhower exemplified have been a pole star for me during my public career. I was very proud that Mamie Eisenhower was the honorary chair of my first campaign for governor here in the Commonwealth. And their grandchildren, Susan and David's wife, Julie, have been good friends and good citizens of this Commonwealth and of the United States. Last but certainly not least, as you've heard, I treasure my association with Gettysburg College. In my view, one of the premier private institutions of higher learning in these United States, from which I am pleased to note I hold an honorary degree, granted during a weak moment in 1980 when I had served as governor. No cash was exchanged. We're here this evening to observe yet another historic milestone. This summer, we celebrated the 20th anniversary of the signing into law of the Americans with Disabilities Act, or the ADA as it's commonly known. A landmark civil rights law and a declaration of independence for some 50 million Americans with physical, sensory, psychiatric, and intellectual disabilities. Now I'm going to repeat a little experiment I carried out with students earlier today and ask any of you who has a family member or a friend who has a disability to just raise your hand. And that shows, I think, when you look around this room, the stake that we as a nation have in providing basic rights for people with disability. And the other reminder, of course, we have is that all of us are only a split second away from disability ourselves if we should happen to befall that fate. Tonight, I want to share with you some of my experiences and views, both personal and professional, as a longtime advocate for disability rights. In particular, I will focus on the role played in my life by the ADA, the most important civil rights legislation since the 1960s. Let me begin with a story. As some of you may know, on July 1, 1960, just over 50 years ago, our son Peter, then an infant only 4 months old, was involved in a terrible automobile accident that took the life of his mother, my first wife. For a considerable period of time thereafter, Peter's very survival was in doubt. He had suffered multiple skull fractures and extensive brain damage that were to result in severe physical and intellectual disability. After 6 months of intensive hospital care, under the loving supervision of the Sisters of Mercy in our hometown of Pittsburgh, during which time he was actually baptized with tubes running in and out of his tiny body, Peter returned home just before Christmas, and we began life anew. I spent 3 years as a single parent to Peter and his 2 older brothers, but was then blessed to meet Ginny Judson. Some of you know her, and in fact, a few of you asked why she wasn't here tonight to give the speech. She was then a 23-year-old school teacher, and we were married 47 years ago. In 1966, Ginny and I added a fourth son to our marriage. She's been a model mom to our family and a super granny to 6 wonderful grandchildren as well. Inspired by Peter, Jenny became an effective advocate for people with disabilities at the local, state, and national level, serving ultimately as president of our local Association of Retarded Citizens and as a member of President Reagan's Committee on Mental Retardation. She is today, as you heard, the director of the Interfaith Initiative at the American Association of People with Disabilities in Washington, D.C., helping religious congregations of all faiths to identify and remove barriers to worship for persons with all types of disability. But her most important advocacy was and is on behalf of our son, Peter. Peter Thornburgh, today, at age 50, is still very limited, but he lives semi-independently in a supervised apartment near Harrisburg. He works as a volunteer at the Central Pennsylvania Food Bank, where, in his words, I help poor people. He has his own circle of friends, and he is welcomed by his church and in many other community activities. What an inspiration he has been for all of us who have shared his journey. What lessons have we learned from these experiences with our son? First, and perhaps most important, to focus on the abilities and not the disabilities of all individuals. Secondly, to seek to maximize the opportunities for inclusion of persons with people with disabilities in the mainstream of our communities. Third, to embrace all such persons within family and community. There's something about this relationship that works both ways. Our family, I must tell you, has gained as much from Peter as he has gained from us. Fourth, to recognize that disability is part of the very fabric of life, simply one more of life's challenges to be met, and certainly nothing to be ashamed of. Fifth, to celebrate the value of efforts of those who train, educate, and advocate for people with disabilities, and of parents, family members, and friends who partner in these efforts as well. As good fortune would have it, I have also been blessed with opportunities to apply these lessons in public life as well. In 1979, I began my 2 terms as governor of Pennsylvania after winning a hard-fought election for that office. Peter, it turned out, was a fine campaigner and a frequent participant in official activities when I was elected. Our feeling was one of pride in his accomplishment, not of reluctance to share his shortcomings. Everyone in Pennsylvania knew that the governor had a son with a serious disability, and this helped, we thought, to give heart to many in similar situations across the state. During the 1980s, when I served as governor, we put an emphasis on providing community-based services for children and adults with disabilities as an alternative to large and impersonal and often isolated institutions. We emphasized mainstreaming for all persons. We promoted independent living and supported employment opportunities to help provide the dignity and financial independence that can only come from a job. And we created a respite care program to provide some breathing room for devoted parents and other caregivers. Later, when I was in Washington, D.C. as Attorney General of the United States in the cabinets of Presidents Reagan and George H.W. Bush, I was provided yet another opportunity to merge my personal and official agendas. One of my principal tasks for President Bush was to spearhead the effort to obtain congressional passage of the ADA. As you know, that law was designed to end discrimination against persons with disabilities and to remove barriers to employment, public services, public accommodations, transportation, and communication facilities. The ADA developed bipartisan support in the Congress, a commodity in scarce supply these days. Under pressure from the disability community, in cooperation with parents, professionals, and providers who saw the need to extend the protection of civil rights laws to those with disabilities. This bill was not a quota bill, one designed to give special preference or set-asides to persons with disabilities, but was fashioned to empower them to participate in the mainstream of American life. On July 26, 1990, the bill was signed into law by President Bush on a glorious summer day. In a ceremony held on the south lawn of the White House, some 3,000 persons with and without disabilities and their family members looked on and cheered as President Bush called to let the shameful wall of exclusion finally come tumbling down. It was a great day. What's been the effect of the act? Before its passage, despite heroic efforts by advocates, the country's existing laws and social benefits programs had proved inadequate. Vast numbers of individuals with disabilities lived in isolation and dependence. People with disabilities couldn't get a job, ride a city bus, or go to a restaurant or county library. We as a society had failed to eliminate architectural, attitudinal, and communications barriers, all of which impose staggering economic and social costs upon our country. After 20 years of the ADA, we see significant changes. New designated parking spaces at the local convenience store, a ramp at the neighborhood movie theater, a sign language interpreter at public meetings, Braille on the ATM machine or in the elevator at the local hotel, and most of all, persons with disabilities gaining more access to community living and to employment, although clearly not yet in the numbers we would like to see. Employment in particular is problematical, as there has been no net increase in the number of employed Americans with disabilities in the past 20 years, a challenge exacerbated by the present economic downturn. The ADA has been good for people with disabilities, but more important, it has been good for America, helping to fulfill the promises inherent in our democratic ideals. And best of all, according to a nationwide NOD Harris survey, nearly 9 out of 10 Americans aware of the ADA approve of the act. Challenges remain, to be sure. Too many Americans still fail to appreciate the essence of the discrimination that people with disabilities face in their daily lives. Many Americans still don't see barriers to full inclusion, whether based on architecture or attitude. Many Americans still remain trapped by society's stereotypes about disability. Many Americans still think the barriers faced by people with disabilities stem primarily from their disabilities and not from what we as a society have erected. It's also essential that we better educate people with disabilities about their rights and help them develop an expectation of equal treatment. Until recently, many people with disabilities had no choice but to internalize the exclusion and unfair treatment they experienced. Discrimination and unreasonable barriers were things that people with disabilities had to accept. This was doubly harmful. Not only were people with disabilities excluded from important societal activities, but they were also sent a message that such exclusion was legitimate and natural. Well, it isn't. You know it, I know it, and now all America is learning to know it. Discrimination and exclusion are morally wrong, and it is important that we make sure that people with disabilities know that it is wrong and know there is something they can do about it. Progress is being made, to be sure, but this is no time to rest on our laurels or to savor our accomplishments. important issues remain unresolved, as the ADA has moved from public debate in legislative halls all the way to the United States Supreme Court. Increasingly, the Supreme Court has been called upon to decide a number of issues arising from the passage of the ADA. Many of these cases are fact-specific, not surprising in view of the broad language of the Act, but many have involved important policy decisions as well. While the results have been mixed, a major reaffirmation of the rights of persons with psychiatric or intellectual disabilities to live in the community was forthcoming from the justices in the Olmstead case, in which I was privileged to file a friend of the court brief. Justice Ruth Bader Ginsburg wrote the majority opinion, which found unnecessary institutionalization to constitute discrimination based on disability under the ADA. Her opinion stated, and I quote, "Under Title II of the ADA, states are required to provide community-based treatment for persons with mental disabilities. When the state's treatment professionals determine that such placement is appropriate, the affected persons do not oppose such treatment, and the placement can be reasonably accommodated, taking into account the resources available to the state and the needs of others with mental disabilities." End of quotation. While falling short of the ringing endorsement of community-based services that many of us hoped for, the court did strike down arguments made by forces arrayed to keep in place that shameful wall of exclusion about which President Bush spoke. Efforts to gut the ADA provisions designed to promote the integration of persons with disabilities into the mainstream community were rejected by a 6-3 margin in the court. The court specifically refused to overturn a lower court decision obliging states pursuant to the ADA to provide programs and services in the most integrated setting appropriate to the needs of individuals with disabilities, pursuant to regulations which I had issued while serving as Attorney General. All friends of the disability movement were pleased with this positive result, even though it left a number of nuts and bolts questions still unanswered as to the specifics of the right to receive services in the community. Thereafter, other serious challenges were raised to the constitutional reach of the ADA. In Garnett versus University of Alabama, for example, the court decided that states cannot be sued by their citizens for damages in the federal courts for violating Title I of the ADA, the part of the act that precludes public entities such as states, cities, and towns from discriminating against people with disabilities in the area of public employment. While fatal to only a small proportion of remedial actions in the courts, the Garrett decision definitely represented a step backwards, and this decision, in view of many observers, relied upon a cramped reading of the intent of Congress in passing the ADA. Those of us interested in disability rights took heart, on the other hand, from the Supreme Court's decision in Lane versus Tennessee, also a case in which I filed a friend of the court brief. There, the court refused to extend the reasoning in the Garnett case to claims under Title II of the ADA addressing access to government services, at least insofar as access to the courthouses is concerned. All of this may sound like lawyers' quibbles over particular sections of the Act and their application to fact situations. But there has been a response. Remedial legislation has been undertaken, most notably in the ADA Amendments Act of 2009, to cure some of the anomalies arising from adverse court decisions in the field of employment law. The Help America Vote Act also contains specific provisions designed to fully empower Americans with disabilities in the exercise of that most precious of all rights in a free society, the right to vote. Needless to say, a raft of other issues await determination in our courts as the legal parameters of the ADA become more fully developed. And we still await the full effects of the recently passed congressional reforms in our healthcare system. This legislation, for example, expanded Medicaid eligibility And as a result, many states are already proposing near draconian cuts in their state Medicaid budgets. The fact that all Medicaid home and community-based services are optional makes them particularly vulnerable to being cut as states begin to further tighten their budgets. The effect of such action on Olmstead initiatives, for example, could be devastating. And this brings me to my closing comment. As a former governor of this great Commonwealth, I know that our agenda must be more than simply a federal agenda emanating from the Congress and from Washington. Our efforts must be national in scope, encompassing both federal and state action. As we continue down the path of devolution of one-time federal authority to the states, there are a number of issues that will remain in the lives of people with disability that will challenge state and local officials as well, especially in these times of tight budgets. Let me give you some examples. Under Olmstead, states will be increasingly obliged to deal with lengthening waiting lists for placement in community facilities and with low salary levels for non-state employee direct caregivers. School districts, absent significant funding commitments, will find it harder to include students with disabilities in the mainstream of our local schools. In addition, special education dollars will be increasingly obliged to compete with regular education appropriations. State and local rehabilitation agencies will have fewer federal funds and larger numbers of people with disabilities who qualify for vocational rehabilitation training, in apparent competition with those seeking to move from welfare to work. Long-term care priorities, too, may well work to pit the interests of the elderly against those with disabilities. Local housing authorities, where demands for housing assistance always outstrip funds available, will find themselves consigned to a pecking order that will not be advantageous to citizens with disabilities. In a world already affected by an ongoing NIMBY, not in my backyard, attitude. Continued pressure will come from public employee unions and state-related operations whose interests conflict with the transition to community-based facilities staffed largely by a non-unionized private sector workforce. Finally, I cannot help but note the need for our United States Senate to promptly ratify the United Nations Convention on the Rights of Persons with Disabilities, which would help to extend the principles of the ADA to those estimated 650 million people with disabilities around the world who lack any such protection today. No better opportunity exists for America to reassert its traditional role of leadership with regard to human rights around the world. In closing, I have to tell you that when I look back on all that's been accomplished through the passage of the ADA and other laws dating all the way back to Section 504 of the Rehabilitation Act of 1973, I quickly come to realize that none of these statutes and laws were on the books in 1990 when our beloved son Peter was so seriously injured. It is only during his lifetime, in the last 50 years, that we have taken these giant steps forward. We still have quite a way to go to see that every American with a disability has a full opportunity to develop his or her abilities within the school setting, the workplace, and in the community. But much progress has been made, and much new hope has been introduced into the disability community by the landmark legislative effort that produced the ADA. The level of appreciation of the barriers faced by persons with disabilities and the steps that must be taken to overcome those barriers have never been better understood by American citizens than they are today. Let us hope that we can continue to hold high the banner of inclusion and full participation in our society for those with disabilities as we observe this 20th birthday of the ADA. This cause deserves no less. Thank you for asking me to join in the celebration of this birthday and of our commitment to liberty and freedom for all. Thank you very much. Thank you.